Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss one of the most crucial topics in the criminal justice system of India, which is the witness protection. Okay, now we will go a little bit into the jurisprudential history of criminal justice system. Since we are doing criminological discussion on criminology also in on our channel, and if you have gone through those videos, we are actually discussing the approaches and the whys of why a person is committing a crime, right? So now when we talk of criminal justice system, it has various stakeholders, right? So we have criminal or offender who is punished by law if he is convicted. We have a victim, but the third edge of this particular justice system is also witness. Okay, so since we are evolving, the jurisprudence is evolving, criminological jurisprudence is evolving, we are observing that there is a shift. Okay, so earlier we were focusing on the retributive part of the justice, which was saying that if you have done an offense, you will be punished equally, right? On deterrence, that if you have committed a crime and we let you go easily, it will not create a deterring effect, so punishment needs to be harsh. Then when Bachchan Singh case happens, okay, Bachchan Singh comes, we move towards a more reformative approach. Okay, so now we are also taking in account the rehabilitative justice for the criminal, and side by side we are also looking towards a victim centric perspective to rehabilitate the victim, to restore the victim, and to provide victim with the care. Okay, so we do have provisions like section 396, 395 in the earlier CrPC, but when it comes to witnesses, there was no provision. Okay, so witness was often an ignored element since the case of Neelam Katara happened, particularly. Okay, now witnesses, we know how crucial witness is for a criminal proceeding, right? Witness can, a witness statement given by witness can turn the fate of a case as well. Okay, and therefore protecting witness also becomes a very crucial element of the criminal jurisprudence. Now, anyway, there was a legislative gap that we never provided for witness protection guidelines. We did have provisions for victim compensation. We did have provisions for ensuring victims are fine, but we never actually paid that much attention to, how do we protect the witnesses as well. Okay. Now, this particular discussion is going to revolve around how witnesses are protected in our criminal jurisprudence, in our legal system. Okay. Now, when we talk of witness protection scheme, it is incorporated in section 398 of the Bharatiya Nagarik Suraksha Sanhita, which is the new criminal code of the country, right? It has in section 398 the witness protection scheme, which provides that every state government shall prepare and notify a witness protection scheme for the state with a view to ensure protection of the witnesses. Okay, so we need to protect the witnesses because every day we hear cases like the witness to this particular case is abducted and killed, and the witness to this particular case was threatened that his family would be harmed. Even if you see TV shows, even if you see movies which are relating with crime scenes, there can be tampering with the witnesses, there can be threatening done to witnesses, right? So we know that this is something that happens, this is a reality that is out there, and we need to address that. So to address that, we have section 398 in the BNSS. Now, it did not find any place in CrPC, the earlier CrPC, which is now repealed by the Bharatiya Nagarik Suraksha Sanhita. But bringing such a provision is a cumulative result of many judgments like Neelam Katara and the Zahira's judgment as well, which was given by the Supreme Court. Okay, so we will be coming to it one by one, and I will first start with where it all starts. Neelam Katara Delhi High Court judgment marks a significant shift in the witness protection jurisprudence in India. Okay, so Neelam Katara's case, the Delhi High Court recognizes the need of witness protection. It recognizes that witness is a crucial element. Okay, earlier we had in IPC, in BNS, if you see, we have provision like forgery, perjury. Okay, so you cannot fabricate evidence, you cannot give false testimony. Okay, so that a fair trial can be ensured. But have we looked at the other side, that what if what if the witness is threatened? How do we cater to that? So Neelam Katara takes into account that particular position. In Neelam Katara, basically a witness was abducted and killed, and therefore this case lies before the High Court of Delhi. And herein, okay, so Honorable High Court of Delhi is observing that there is a legislative gap, that we have not provided for witness protection, and witnesses are also a crucial element of the criminal justice system. Now, any one of us, let's keep aside the academic discussion, okay, academic legal discussion, let's keep that aside. Any one of us, even if the audience who are viewing this video, even if you are not in the law field, you are not doing your LLBs, and you are not practicing advocates, even if you are in any profession, you can anytime be a witness. Okay, then what is your fate? What are your rights? How would you be protecting yourself? Because often, you will be given a notice by the authority. So maybe some authority, maybe police inspector, maybe the investigating officer, maybe the police station, maybe the CBI, maybe the ED, they might give you a notice of appearing before the investigating authority, and you would feel that, how do I handle that? Okay, if I become the witness, am I under threat? What would happen about me? Okay, so this particular discussion caters to how witnesses are protected under our criminal justice system. Okay, so in Neelam Katara, the court is giving a very crucial, a very significant judgment about witness protection, because the court says that till a suitable legislation is brought on the statute book, we direct that these particular guidelines shall be in operation, okay, for the witness protection. Now the court herein is saying that if a witness finds himself threatened, okay, and the Honorable High Court of Delhi is saying it to Delhi State Legal Services Authority as the competent authority, that if a person who is witness and he is finding himself threatened, it is the authority, and it is the duty as well of DALSA, of Delhi State Legal Services Authority, to provide protection to the witness for crime which is punishable with capital punishment and life imprisonment. Okay, any offense which is punishable with capital punishment or life imprisonment, if you are a witness to that case, DALSA is going to provide you protection if you apply for that, if you feel threatened, or if the case necessitates so. Okay, now Delhi High Court is observing that because there is a legal gap here, there is a legislative gap here, and the problem is prevalent. Okay, witnesses often comes under threat, their families are under threat, their property, their reputation is under threat when they become witness. Okay, then it is also the duty of the state to protect them, because there have been many reports, okay, many judgments that have said that witness plays an important role in determination of a criminal trial. But what are we as a state doing to ensure that they are protected? What are we doing to facilitate that witnesses do come and give testimony and they don't get afraid of it? Okay, so now this particular High Court, Delhi High Court, is issuing guidelines, and they are saying witness means a person. For the purpose of this judgment, witness is a person whose statement has been recorded by the investigating officer under section 161 of CrPC, which is now section 180 of the BNSS. So if your statement is being recorded under the given provisions by the investigating officer, you are the witness. And in this particular case, you are witnessing against a crime which is punishable with death or life imprisonment. Okay, and now the court is issuing guidelines that a witness to these cases where punishment is capital punishment or life imprisonment, the witness needs to be protected, that by the police officer. He should be given police protection, and while affording him protection, these parameters are needed to be taken into account. Okay, what is the nature of the risk to the security of the witness? If it is a high profile criminal case, there are some political leaders involved, there are some big personalities involved. Will his security be threatened? This is to be considered. Number two, what is the nature of the investigation of the criminal case? Okay, or what is the nature of the criminal case? Okay, if it is a petty offense, you might not need to give the police protection. Okay, and what is the importance of the witness? Is the witness is the testimony, is the statement of the witness so crucial that it might lead to conviction of that particular offender? That is also to be determined, that how important is the witness's statement. Okay, what is the information he might give, what is the evidence he might produce, right? And what is the cost of providing police protection to the witness, whether it comes in the cost friendliness. And cost friendliness becomes a lesser parameter to be taken into consideration. And you need to consider these three parameters more, because cost anyway would be covered. You need to protect the sanctity of witness protection, right? Now court in this case said that when an investigation officer is inquiring, pardon me, when he is investigating the person and recording his statement under section 161 CrPC or 180 in the BNSS, it is the duty of that particular investigating officer to tell these witness protection guidelines to the witness. Okay, and the investigation officer will inform in writing, duly acknowledged by the witness, that it shall be informed in writing, duly acknowledged by the witness, that I have been told the witness protection guideline by the police officer. Okay, by the investigating officer. And it is also the duty of the police commissioner to provide security to a witness with respect of whom the protection orders may be passed with respect to his protection. Okay, so now this is what particularly the Neelam Katara's judgment is saying. Okay, and Neelam Katara's judgment basically, and main more such judgments, later on given by the Supreme Court, they basically made the way for witness protection scheme that has been implemented by many states. Okay, now I would just take a minute to inform you that I am using all the resources that are available online. If you want to dig more into it, you can go to the DALSA's website. I'm using Delhi State Legal Services Authority as the source to disseminate this information here. And now we move to the witness protection scheme. Okay, pursuant to this case, pursuant to many cases the Supreme Court adjudicated, there is a witness protection scheme drafted. Okay, so there was one drafted in 2015, implemented also. Then there is 2018 witness protection scheme. This is also available on the DALSA's website. You may go and have a look at it for further information. Some important aspects of it we are going to deal with in this particular video. Now, witness protection guidelines, they are, of course, witness protection scheme. It is, of course, formulated to ensure that investigation, prosecution, and trial of the offenses, it is not prejudiced because witnesses are threatened or intimidated, or they are frightened. Okay, so they should be protected because, of course, witness testimony, witness statements plays a very important role. Okay, now, there is a quote that they are using of Jeremy Bentham, who says that witnesses are the eyes and ears of justice. In cases involving heinous crimes, witnesses often turn hostile because there is a threat to their life and property. Okay, so number one, the witness should not turn hostile. Number two, he should not be intimidated. Number three, he should not be frightened. Number four, he should be protected. His life should be protected. To ensure all of these things together, witness protection scheme needs to be there. Okay, now this particular reference was also given in the Zahira's case, which is Zahira Habibullah versus State of Gujarat. It is a 2004 Supreme Court case, and Supreme Court herein is holding that if you want a free trial, okay, if you want a free trial, you need to ensure that witnesses are not threatened and they're not changing their testimony, or they're not giving the false evidences, right? So there are also some law commission reports. There is 14th law commission report. There is also 198th law commission report, which is recognizing the witness, which is recognizing the need of witness protection. Some reports are advocating for protecting the witness, and some are advocating that their identity also needs to be protected. Okay, so now when we look at this particular, so there are many objectives. Also, in the case of Mahinder Chawla versus Union of India, there was the Supreme Court said that these guidelines need to be approved. Okay, so pursuant to these cases, pursuant to Neelam Katara, we have witness protection guidelines, and now the CrPC, now the newly enacted Bharatiya Nagarik Suraksha Sanhita, it validates the witness protection scheme as a legislative provision as well. So it is backing up all these witness protection schemes. Okay. Now, not that they were invalid earlier, but now there is legislative backing to this particular provision of witness protection as well. Now, when we look at witness protection, okay, so how will you be protected? We are going to look at the crucial discussion herein. So this particular scheme is dividing witnesses into three categories. Okay, so first category is when there is a threat to the life of witness or his family during the investigation or trial. Okay, category B is when this threat extends to safety, reputation, or property of the witness or the family member where there is investigation or trial happening. Okay, category C is where threat is moderate, okay, and extends to intimidation of the witness or his family members. All right. So, there are three categories. First is when there is immediate threat to life of the witness or his family members. B is when, it is extending to safety or reputation or property. Okay. And C is when threat is moderate and will only have an intimidating effect on the witness. Okay. So based on these category also, we will segregate what kind of protection shall be given. So how will we protect the witness? Okay, that is given in this part. Okay, so what are the type of protective measures? Okay, now there can be that if there is a witness who is under threat, okay, if there is a witness having threat to his life, his family members are threatened, protection measures shall ensure that witness and accused do not come face to face during any investigation or trial. Okay, so they will keep protecting the witness. They will also monitor the email or telephone calls if accused is threatening him in some manner. Okay, and there can be arrangements of security devices in witnesses' home for security purposes. For example, security door locks, CCTVs. Okay, also the identity of witness can also be concealed depending on the case. If that has to be concealed, that has not to be given out in the air, or that has to be protected. Looking at the sensitivity of the case, that particular thing can also be done. Okay, a regular patrolling around the witness's house, witness's location. If needed, witness can also be relocated to some other premises. Okay, and witness the change of residence can also be done. Okay, and if needed, witness will be protected in a manner that he will be escorted to and fro from the place where investigation is happening or the court where trial is happening. Or okay, in camera trials can also be held when witness is in question. Okay, what is in camera trials? You are going to tell me in the comment box below. Okay, take the quote, pardon me. In the protection guidelines, it can also be allowed that there is always a support person present with the witness. Okay, so you may use live links, one-way mirrors, etc. for protecting the identity or concealing the identity of the witness. All right, and audio modification, audio video modification is also permissible. Okay, then we have now when we have BNSS, we also have provisions for online or online inquiry, online investigation as well. So that can also be done. Okay, ensuring expeditious recording of deposition on day-to-day basis without adjournment, so that witness is easily able to give his statement and go away from the particular trial scene. Okay, so these time to time periodic financial aids or grants can also be given to the witness. If witness is threatened, there is also a witness protection fund. Okay, so when we were understanding the categories of witness, so there is state witness protection fund also that is designated there. Okay, and a budgetary allocation has to be made by the state government. Okay, so if there are requirements of compensating, of giving that particular financial aid to the witness, that can also be done as a relief. Okay, so these are some kind of protection measures that can be given to the witness. Okay, then there is a provision of protection of the witness's identity, but all of these particular provisions will be applicable depending on the need of the case, because Neelam Katara is laying down parameters that you will be considering while allowing the witness protection. Okay, what kind of witness protection is needed, what degree of witness protection is needed, how many days do we need to protect the witness for? All of that shall be decided by way of these four parameters. Okay, Now, also, identity can be protected, identity can be changed also depending on the case to case basis. Relocation of the witness can also be done, witness to be apprised of this scheme. Okay, every state government shall be publicizing this witness protection scheme. Every state that is making this particular scheme, that will publicize it, and the investigating officer and the court shall first inform the witness of these guidelines also. Confidentiality shall be preserved. All of these provisions will be followed in order to ensure the witness protection. Okay, now when we are coming to the last element of the discussion. So this particular witness protection scheme provides a performa that you can fill if anytime anyone appears as a witness and needs the protection. So this is the performa that is also given in the witness protection scheme, and this whole PDF is there on the DALSA's website. If you are not in Delhi, if you are from any other state, it will be available on your state legal services authority website, because courts have authorized the legal services authorities of the states to act in this particular purpose, right? Section 398 is backing this provision up, and these are the framework, these together form the framework for witness protection in India. Okay, so this is it for the discussion on witness protection. I hope the discussion is useful. For more such videos, please stay tuned with Legal Darshan. Have a great day. Again, I would like to reiterate that all the resources that we are using in the videos that are aiming to disseminate general information, general legal information at large, they will be disseminated using public resources that you can also access easily. Okay, so these are the publicly available resources. DALSA's website with witness protection scheme is also uploaded herein. If you scroll down, it is here. And then the Indian Qanun's website for using the section to have a discussion here. Thank you for watching. Please stay tuned. Have a great day.